All right, everyone. Will, are we expecting Ian tonight?
To the best of my knowledge, yes. I haven't heard anything.
Okay. All right. Well, it is 5 o'clock, so we will get tonight's meeting started. Welcome everybody to the February 2nd meeting of the Nantucket Conservation Commission. This meeting is being held entirely remotely with participants participating via Zoom app. The public can participate via YouTube, and there are directions on the town's website detailing how you can join. I ask that anybody wishing to speak tonight, please raise your hand either in your camera window or virtually and wait to be recognized by me. When you're allowed to speak, make sure to state your name and any relationship you have to the project, whether you're an abutter, a project applicant, what have you, so that is clear in our meeting minutes. I also ask that anybody on the meeting, please keep yourself muted if you're not speaking, so that we don't get any weird feedback or distract our minutes taker. And with that, we will begin tonight's meeting with public comment on items not being heard. And I see Megan Perry with a hand up.
Thank you, Madam Chair. I just wanted to talk to the commission really quickly about a matter that came up. I received an email from Jesse Leddick with regards to a conservation management permit. And it was sent out to 3 different departments. One department was the Concom, one department was the Planning Board, and another was the Select Board. This is the conservation management permit for Surfside Crossing. And I think this would be a great opportunity to start to address open management plans and the Concom having some more say in them, because this permit had a 21-day appeal period that was not used because no department mentioned it to their boards or commissions or the public. We missed that appeal period. And now the open space management plan for this project is plus or minus 2.08 acres of open space, which is roughly, the plans roughly show about 20 feet on the front side of South Shore Road and 10 feet on all the other sides. And I think this commission can probably guess that that's not a really great open space management plan. Furthermore, they were able to do an in lieu mitigation of $641,796 to try to mitigate open space and the endangered species on that site. So we're not going to find 11.5 acres on Nantucket that's undisturbed for that. You're not going to find an acre on Nantucket undisturbed for that. So that the funding is going to go off island. All of those things could have been appealed had we known about that, or even if the Concom had been brought in on the open space management plan. I understand that this permit did not have wetlands in it or coastal banks or any of that stuff. However, it did deal with open space management. And so I was wondering if this commission would consider looking into having more say and teeth in the open space management plans in the future and conservation management plans, especially those that come down from the state. Additionally, if it would be possible to make sure that the public is aware when these permits do come across the table, that would be awesome. So if anybody wanted to appeal, they could. Thank you so much for the time.
Thank you, Megan. It's definitely an important topic. I know Seth has brought up most recently during our regulations updates meeting, the Conservation Commission taking a little bit more of an active stance in open space, as that is allowable per the state. So that's something I think we will bring up for further discussion. So thank you. Linda, I see your hand up.
I'm not sure that Concom has any jurisdiction here at all. My understanding is, because I live on South Shore, off South Shore Road also, my understanding is that they have the requisite permits to do the cutting that they're doing. They don't have, at their own risk, but they don't have any building permits to dig a hole or anything else. And they don't need anybody's approval to put up a split rail fence, which I saw that they put up. And the state is making them put those posts up, indicating where open space and all this other stuff is. I haven't looked at all the posts. They annoy me. but apparently they have the right to do what they're doing right now. And the Concom is not involved in any of this, to my understanding.
No, and Linda, you are correct, and I do want to kind of prevent back and forth on an issue that's not on our agenda. But essentially, the legislation that enables conservation commissions also enables us to have a say in open space planning. And in this instance, we could have reviewed the natural heritage document and at least weighed in about it. It's not something that we currently do, but it's something we are able to do, and something
Okay.
that we should probably discuss with our regulations update about maybe playing a little bit more active role in the community as far as some oversight.
That makes sense, because I know that the approval from the state was at least a year or two old. So if we want to go forward, we should probably have a discussion about that, but not with this project. It's already gone.
Oh, right. No, we're too late for this project, certainly, but this would prevent kind of natural heritage permitting like this from flying under the radar. It would again just give another layer of oversight that it seems like might be important.
It makes sense to do that, because it doesn't just stop with this project. There's other projects out there.
Yes, exactly. Megan, do you have a follow-up?
I did, just super quickly. I don't want to take up any more of your time, but I did ask Natural Heritage who they generally send the permits out to, and they said relevant departments, which is, and this is to quote them, they did say select board, planning board, and conservation commissions. So Natural Heritage themselves finds the Conservation Commission a relevant department to send these permits out to. And I'm not asking the Concom to weigh in on this exact project. I'm looking towards the future. I'm well aware that this project is long gone and we've passed the appeal period. I was just hoping that the Concom would consider future oversight on open space management plans.
Thank
you.
Thank you, Megan. I see Seth's hand just went up, and then Joe, I see you as well.
I'll be very brief because we're in public comment, but the role of conservation commissions throughout the state is fourfold. It's to protect and acquire open space, to better manage open space, to manage wetland resource areas, and to provide education and outreach to the community about those resources. So it is within one of those four roles. And I think we should have a further discussion about it at a posted agenda item.
Thank you, Seth. Joe?
Yes, at the last, we lost our scribe. Do we have a replacement?
So staff is taking minutes.
Okay,
Yeah, that's on the Natural Resource Department. So it looks like Will has taken that over. All right, I just will check YouTube for any public comment. Does not appear that we have any other public comment. So the following items tonight are continued. We have Nantucket Boathouse LLC at 2 and 6 Easton Street, continued until February 16th. We have 78 Wauwinet Road LLC at 78 Wauwinet Road, continued until February 16th. And then we have Nantucket Islands Land Bank at 55 Warren's Landing, continued until February 16th. So we will begin tonight's meeting under notices of intent, AC Hang 10 LLC at 21 Meter Street, represented by Art Gasparo.
Thank you, Madam Chair. I'm before you tonight with the continued public hearing related to 10 Meter Street. And we filed some revised and supplemental information with the commission in response to the discussion and some of the concerns that we heard from the commission at the last meeting. So I'd like to quickly go over those. First, the applicant has agreed to remove the landscape timbers that are around the perimeter. Again, we don't believe that we're going to have an impact on protected interests. However, given that the commission, some commission members expressed concern you know, we don't want you to have a project that you're concerned with, so we will agree to remove those. And then what we have added is there was some discussion about revegetating some of the property. And so what we came up with is shown on the plan in blue would be a vegetated rain garden across the rear of the lot. And that would serve to have an area for some of the stormwater runoff to both collect and then infiltrate into the ground. And we would plant that with wetland species, including a seed mix that I've included the specifications for what would be included there. And then some shrubs that are specified on the plan, wetland species around the perimeter. And we believe that this will further enhance protected interests in the area and specific to both land subject to coastal storm flowage, as well as concerns that the commission had expressed. And with that, we'd be happy to address questions or concerns that you may have with the application.
Ashley, you're on mute.
You're muted, Madam Chair.
Ian, do you want to take over?
Yeah.
Ashley, sounds like.
Yeah, sorry about that, guys. The screen share took over and wouldn't let me come back. I'm a little glitchy tonight. Any questions or comments from commissioners? Seth?
Thank you, Madam Chair. And I apologize in advance, 'cause this is going to be a bit lengthy. But my comments, I'll say, first of all, relate primarily to the Nantucket local wetland regulations, not to the Massachusetts Wetland Protection Act. And they have to do with the potential that there is isolated vegetated wetland on site, in addition to the land subject to coastal storm flowage. So I want to talk about a site visit that myself and staff and some other commissioners did to the site on Monday. We went out to the 21 Meter Street site and dug some soil test pits, and I encountered groundwater at, around 8 or 9 inches below the surface. And I'm confident that this was groundwater because I saw evidences of hydrostatic pressure. So when the hole was dug, water was coming up from the surface and pushing up towards the surface rather than draining downwards. And then I know staff went back on Tuesday. I'll admit I'm not a professional soil scientist. Staff went back on Tuesday and did additional soil sampling with soil auger, soil ruler, and documented groundwater in the site at 7 inches below surface grade. This has all been documented with photos. I know photos from staff were submitted to the commission. I don't know if they were added to the pack or not. I also sent my photos to the staff, which I don't think were circulated, but can be if needed. So given that, I want to point us to our Nantucket local regulations. Or actually, before I do that, I just want to remind the commissioners and the public that there are 3 characteristics for determining vegetated wetlands in Massachusetts: soils, vegetation, and hydrology. And DEP has said that on disturbed sites, soils are the most important of those things. Hydrology is not particularly important here because hydrology is more related to bordering vegetated wetlands rather than isolated vegetated wetlands. So we'll just focus on soils and vegetation today. So I want to read our definitions in our regulations for freshwater marsh and wet meadows. Freshwater marsh is areas where a plant community exists in standing or running water during the growing season, and or where depth to high groundwater is within 18 inches of the surface, and or where soils exhibit hydric characteristics, and where a significant part of the plant community is composed of, but not limited to or necessarily including all the following plants or groups of plants: arums, bladderworts, broreeds, buttonbush, cattails, duckweeds, eelgrass, frogbits, horsetails, hydrophilic grasses, leatherleaf, pickerel weeds, pipeworts, pondweeds, rushes, sedges, smartweeds, sweetgale, water milfoil, water lilies, water starworts, or water willow. And then getting to wet meadow, areas where groundwater is at the surface for a significant part of the growing season, and or where depth of high groundwater is within 18 inches of the surface, and or where soils exhibit hydric characteristics, including modeling within 18 inches of the ground surface, and where a significant part of the plant community is composed of various grasses, sedges, and rushes, made up of, but not necessarily limited to, including all the following plants or groups of plants: blue flag iris, vervain, thoroughwort, dock, false loosestrife, hydrophilic grasses, loosestrife, marsh fern, rushes, sedges, sensitive fern, smartweed, or jewelweed. So given those definitions, we definitely encountered groundwater on the site at a depth of less than 18 inches. There's also photo evidence from before the site was disturbed, indicating that a significant number of these plants, including cattails, irises, and jewelweed, among others that I'm forgetting right now, were documented on site. I also, at the site visit on Monday, documented what I believe to be the sprouts of blue flag iris pushing through the surface. And we could get a botanist to confirm that, but I know for sure it's an iris on site. So I think that given all of those characteristics and the fact that DEP says that on disturbed sites, you can actually delineate wetlands based on soils alone, I think that the area at 21 Meter Street absolutely meets the definition of freshwater marsh and wet meadow. And I would like us as a commission to actually find that it meets those definitions. I'm happy to make a motion to that effect if it's needed. But before I do that, I want to just talk about what the meaning of that is. So then if we go down to the section in our bylaw where vegetated wetlands are covered in our regulations. Sorry. Let me just pull it up. So vegetated wetlands includes meadows, marshes, swamps, and bogs. And the performance standards for vegetated wetlands, the first performance standard in vegetated wetlands indicates proposed projects which are not water dependent shall maintain at least a 25-foot natural undisturbed area to adjacent vegetated wetlands. All structures which are not water dependent shall be at least 50 feet from a vegetated wetland, and all structures shall maintain an undisturbed 2-foot separation to high groundwater. 50% of the area between the 25-foot buffer and the 50-foot buffer shall not be altered. Additional soils and groundwater information may be required for applications in areas of high groundwater. So given that all of that information, I apologize that is lengthy. It is, in my opinion, based off our local regulations, that 21 meter absolutely should be qualified as a vegetated wetlands, and we should apply the relevant performance standards. And I appreciate the changes to the plan that the applicant has made, but I think it's important to actually make the determination that it is an IVW and require potentially more appropriate plants to be planted in the area based off meadow or marsh, and prohibit any structural elements within the appropriate zones. Thank you, Madam Chair.
Thank you, Seth. And I'm sorry that I missed the field viewing on Monday, but I did see the photos that Will sent around and the documented groundwater levels. So thank you. Linda, I see your hand up, and then Mike, I see your hand up.
Through you, Madam Chair, what is Seth suggesting, that we make this lot unbuildable in the middle of all this chaos down there? Or I understand if we make a certain designation, we can require certain mitigation and certain types of plants to be replanted. But where is he going with that?
So
I
Seth,
appreciate the education, but I don't get it.
well, I mean, he wants to make sure that the proper resource areas are delineated on the site. And if that means the site ends up being unbuildable, that's the way that it goes. But he's making sure that we're doing the due diligence on these wetlands. But Seth, do you want to speak for yourself on that?
Yes, thank you, Madam Chair. This has nothing to do with the buildability potential on site. It has to do with appropriately delineating wetlands and applying the relevant performance standards. Even with those applied, waivers can be applied for to overcome those performance standards with suitable justification for those. And there is, I'll admit, albeit a very small area on site that's outside of the 50-foot buffer if we delineated it as such. But this is not about, any personal thoughts about what I want this site to be in terms of a building or not. This is about applying our regulations equally and justly on every site and applying the appropriate science to back that up. Thank you.
More questions, Madam Chair?
Go
Through
ahead.
you. I haven't seen the photos personally. Where the photos come from that are claimed to be historic, and when were they taken? What are the dates? Who gave them to you? Where do we get them? Because in the file, there's nothing. And I'm just curious about that, because there's been alluded to before about these photos that were ostensibly taken at some point. I don't know when, they're not dated. Haven't seen them. So I'll leave that alone for a second. If I know there's just a small area, if we did this, there's a small area outside the 50, what are you going to build? I have to go there because that's coming next, I would assume. What are you going to let them build a shed in the middle of all of the developed area down there? We would not have a leg to stand on in court, not have a leg to stand on at the state, as far as my opinion. But I'm just curious where we're supposed to go if we designate 90% of this lot as a resource area, as opposed to accepting where they want to plant the proper plants. I'm confused.
Linda, so the photos and things that you're talking about, I must admit, I don't know if they're in tonight's packet, but they've been emailed out numerous times and they do have relative dates. So they've been circulated at least twice during this open hearing during email, and David Haynes has spoken to them. And they really, they very clearly show cattail or typha species. Again, we're not here to talk about buildability. The applicant is not asking to build anything. We are just making sure that we have the resource areas delineated properly so that in the future, any application for this site or surrounding sites are looked at with the appropriate resource area boundaries in mind. So this, a proper designation helps everybody in the area. Seth?
I got that, Madam Chair, but the issue is that every single square inch of everything between it and the water has been built on already, obviously with helical piers and, at the proper flood level. Every single lot around it has been built, some of them at grade. And I just don't know where we're supposed to go. It's to make one lot in the middle of all this building a resource area. I have a problem with that, frankly, other than designated certain mitigation areas.
Okay. Well, at some point we'll probably make a motion and you can choose to agree with that or not. I don't think we're trying to pick this lot out. There was just clear historic photographs, and by historic, I mean the last 2.5 years. So, it was evident recently that there were wetland plant species then the site was disturbed without the benefit of a permit. And we've kind of been trying to track and figure out exactly what resource areas were there since then. And it sounds like more evidence, was brought to light this week with some of the soil tests that were done. Mike, I see your hand up.
Thank you, Madam Chair. I'll keep my comments brief. We've been talking about this for several weeks now, but on on the hydrology aspect, I mean, I'm not surprised the groundwater is high there now, given the time of year and the way the lot sits low. I also am just a little bit bothered by photographs of years past without much evidence, but I think that Art has put forth a pretty good solution to this site, and I'm prepared to support that, but that's just my comments. Thank you.
Thank you, Mike. Mark, I see your hand up, and then Seth, I'll go back to you.
Thank you, Ashley. I have a question for Art Gasparo, if I could. Art, what is the history of this property in terms of buildings on that site before it became an empty lot? It had to have something on it, I would think, but can you enlighten me on that topic?
Art, you're muted.
Through you, Madam Chair. I am not aware. I didn't do, extensive historical research on the property. But I have no knowledge of previous structures. There's nothing that goes back on the recent aerials, at least just when I say recent, maybe to 98 that are available on the GIS. I didn't really go, hunting back further than that. I will say there was a lot of debris, on the property, old fences, and it does seem to have been perhaps a general disposal area for some of the other surrounding properties.
That answer your question, Mark? Seth, you had your hand up.
Thank you, Madam Chair. Just a few additional points to clean up some of my comments. It does say that in Performance Standard 1 under vegetated wetlands that an area of high groundwater, additional, soils or wetland or soils or vegetation information may be required. So if we need to collect that information before I make a determination, that's reasonable. I'll admit that, we dug a hole in January, which is a different time than Mr. Garneau did, I believe. From my albeit limited knowledge of hydrogeology, I would think that January would actually be a relatively good time to do it. Spring or fall probably should have the highest groundwater table. Winter should relatively be lower. So if we're finding it at 7 inches in the winter, it's probably even closer to the surface in the spring. But I'll let somebody with expertise in that area I'll defer to them. I'm a wildlife scientist. So, and then just in terms of Linda's comments, I hear you completely about these neighborhood level concerns, but in my opinion, they're really not part of our review. Our job is not to do neighborhood level plans at the Conservation Commission. Our job is to review applications on each site individually and review only what's in front of us. The applicants haven't proposed a building. They've proposed a driveway and what I'll call some landscaping. And in that review, we're not constraining any application that may come forward in the future for any other notice of intent. So we really do need to keep our review related to the application before us and the regulations that document the wetlands resource areas that we're trying to protect. Thank you.
Thank you, Seth. Any other questions or comments from commissioners? Joe?
Where were the holes dug that were dug in the last week?
Seth?
Yes, I can speak to what I did with Will. We did them in the part of the property towards the back. Let me just pull up the map to make sure I have our bearings right. It would be I guess the west northwest corner, where on the plan right now is the proposed vegetated rain garden stormwater basin. That's also where Mr. Haynes indicated that he had seen potential evidence of a vegetated wetland there in the past. So that's where we dug the holes. I don't know if Jeff and Will did other test pits at other parts of the site when they went back on Tuesday when I wasn't there. And I will just say, I hope that these photos have been sent out to applicants and representatives and added to the pack. But if they have not been, they certainly should be to get this into the record. Thank you.
Thank you, Seth. So I, do think that we need to get this wetland properly delineated, given the historic photographs, now the high groundwater that we see. Jeff, do you think making a motion tonight is the best way to go, or do you think we need to get some vegetation evidence? And Art, I do see your hand up too.
If Art had a question, I'll let him go first in case I have to answer something for there too.
Okay, perfect. Art, go ahead.
Thank you, Madam Chair. I think we should take the conditions of the site in context of what exists right now, how highly disturbed, the property is, the fact that, the time of year that this is being looked at, it's not the growing season, that there has been a change of circumstance on the abutting property where the water is completely flowing, all the stormwater runoff for the past, many months, if not year, has been flowing from the adjacent property where they had put a lot of hard pack in and created a parking area during their construction. They've also installed apparently downspouts with leaders that lead to a pit that's right near our property. The water is bubbling out of there during the storm. We saw that on our site visit together. The commissioners that were there saw the water all sheeting off of that property onto our property. This has been occurring while the applicant has, left this property fallow and untouched essentially since the enforcement order was issued. So I think that, the finding of water on the disturbed site under the current conditions should also be taken in context right now and not be considered definitive as to being in conjunction at the same time as when certain vegetation was there. I don't think that's a fair assessment or essentially nexus to make between those two things. The conditions are very different now. The site's been being flooded for quite some time directly as a result of the adjacent property. So I would hope that you would take that, into consideration.
Thank you, Art. We're definitely taking the placement into consideration. I know for me personally, the lot is just in an unfortunate place. I didn't see evidence of direct downspouts. I missed the group site visit you guys did together. But it is a low spot at the bottom of a hill. So, ultimately that positioning is going to lead to more water regardless of what's happening on adjacent properties. I'm also concerned that part of the disturbance was done by the owner of the property. So it's hard to say it's the neighbors causing the problem when, there was, again, disturbance done to the site by the property owner. So it's a difficult one to parse out. Linda, do you have a question? And I do see some public hands up, and I will open it up to the public shortly. Linda, go ahead.
What I'd like to hear from is the applicant or the applicant's representative. I think there's somebody here that may have more history as to how we got here than we have right now, or the opponents have, or board members have. So I'd like to hear from John Trudell or Dewey or one of those guys before we keep going, because I think there may be some information that we don't have, hopefully.
Okay. So the only project rep I have listed was Art for this one tonight, but I understand there are other people maybe on. John Trudell, are you a representative of this project?
Hi, Madam Chair. Yes, John Trudell. I'm actually the realtor for Dwayne Jones, and I'm not sure how much I'll add to it, but if you'll give me a couple of minutes, I'll just give a brief history of the lot and maybe potentially how we got to this point. This particular lot was for sale listed with our company and our real estate company. I was not the listing agent. I actually was the buyer's agent. This was, I believe, at some point, a subdivision of the property on the hill on Union Street there that is directly connected to it, and it was kind of pieced out. Obviously, everyone's familiar with the other surrounding homes that were built on. So as far as wetlands, in selling this lot, I believe there also was a contract with the neighbors across the street that had this agreement to purchase it. And for fear it may be wetlands or some sort, they backed out. And I guess at that point, I don't know if they did their due diligence or research, but when we were approached because Mr. Jones and his wife owned around the corner, I asked if they would have an interest, and the listing agent approached us and said, are you still interested in the land? We obviously said we would, and we did at that point our best due diligence that we could find. And we didn't find anything. From the town records, we hired an attorney, the Brescher and Glidden. They were not able to find anything. So nothing recorded. So, you know, if obviously we found something, our fiduciary responsibility would have been to disclose that. We found nothing. So over the course of time, Mr. Jones hired I believe a licensed expert in this field, and I am not an expert in any kind of conservation, but I guess that's why they hired the expert licensed experts, whatever. So they did soil samples, and I guess they did it in the proper growing season. At that point, the opinion was it was not wetlands. So we're getting to this point where looking at what we're trying to make a designation on what I believe was quoted as potential. And I understand there's due diligence that the board must go through, and I appreciate that. However, the owner has already anticipated that and said, you know, if it was or isn't, or it could be, I'm going to cut to the chase. I'm going to give the concern of the neighbors that wonder if it's wetlands. I'm going to create a space and appease the people that are have the issue with it. So I'm going to take a proactive position, and I'm going to try and mitigate myself by adding it into that. So I think we're at that point where, you know, he did not disturb anything intentionally. If he did disturb, as you said, the owner disturbed the surface, there was nothing recorded that would prevent him from disturbing it. So, and again, I'm just stating my history and position. I don't want to get into a back and forth, and I'm happy to leave it at that. But I just wanted to let you know how we got here, and Mr. Jones's position. It was really nothing other than going through the proper procedures and due diligence.
Thank you. I appreciate that. Unfortunately, in going through that due diligence, it seems like the land subject to coastal storm flowage was missed.
Mm-hmm.
And that's when this site was disturbed, and now there's question whether there was other wetland resources. So there was definitely some holes in that. And unfortunately, the enforcement that was issued for the disturbed area, we're still trying to figure out if there was a freshwater marsh or vegetated wetland. So if this property had come to us as it was purchased without any disturbance, we would definitely be in a different place. Also understand that they had their wetlands expert and appreciate that. We've had a few summers now where we've been in drought conditions, so it's hard at any one test to say like we've nailed it.
Right.
So I think we have to kind of look at that piece too. And certainly with more evidence on the table, it's important for the commission to figure out exactly where our resource areas lie.
And I appreciate that, Madam Chair. I also would like to point out in the beginning of the meeting, as Ms. Perry pointed out, a couple of things, good intentions or otherwise. There are protocols that could be looked at, and mistakes happen. And just as the board, in the future, it's trying to rectify a situation that it doesn't happen again. So this would be a good point, maybe getting something out where before you do anything, a process is missed. And that might have been the same with the Surfside Crossing, which could be, maybe this could be also a learning experience for future properties that come under the same situation, to prevent it from happening again, if that's the case.
Yes, I'm not sure how this property was not listed as flood zone property.
Well, I appreciate your letting me speak. Thank you all.
Thank you. So I am going to open this up to the public now. I see your hand up, RJ.
Thank you, Chair Eversman. Can you hear me?
Yes, we can.
So RJ Turcott on behalf of the Nantucket Land Council. Just like to go back to the last meeting and the last discussion. Mr. David Haynes came in and sort of out of his way to bring out the information he gathered for those folks who were interested in purchasing the property last. And while it was never officially submitted to the commission, because those folks saw that there was likely a wetland on the property and backed out, those people did the right thing. And whether the work that was done on this site was on purpose or done unwittingly, the commission should not reward the filling or alteration of a wetland without a permit, and should require this to be restored and put properly to the grade it was at prior to the work being done. The way it appears with Art's latest submission to the commission, the stuff he has on there looks permittable, but that's a separate issue from restoring what was there properly. Otherwise, the commission would be setting a precedent that folks could look at a lot that was probably difficult and make some alterations and then come into the commission later. So this is an important one to get right for the commission. Thank you.
Thank you, RJ. Linda, I see your hand up.
I'm just curious about something that was said earlier when Dewey bought it. Because I do remember there being a lot of junk over there. I used to work for Alan Holgate and we worked out of there, and he owned the cottages in front of that and the land where Kim's building was put over there and the cottages behind that. I was familiar with a lot from before. I know there was a lot of ground junk. I know there was a lot of plants sort of interspersed with the stuff that was thrown over there from other projects over there, and just people just generally dumping on it because it was the only vacant lot there. So I'm just wondering how much of this lot was destroyed before he even bought it and cleaned all the junk out of it. So I'm wondering, I don't think we can ascribe all the damage done to the quote unquote wetlands resource area to the current owner, when there was I remember a lot of junk being in there. It's just a messy lot. So I'm just, I'm still thinking about that. that it wasn't all his fault, perhaps. But when he cleaned all the junk out of there, obviously it became very clear what was and wasn't there anymore. If based on the photographs that I haven't seen. I'm having trouble with my Comcast and photos.
Yeah, so Linda, I don't know that we have photographic evidence of the debris on site, but there was major soil disturbance and vegetation removed by the current owner. And that's why we issued an enforcement for the site. It's important that even in the flood zone, that's not being done. So, you know, that's a problem. I don't think we can go back 10, 15, 20 years and figure out how the debris got there. But we know that this property owner disturbed the site. Martha Kim, I see your hand up.
Yes, hi. Can you hear me okay?
Yes, we can hear you.
Great, thanks. So for the record, my name is Martha Kim and my address is 46 Union Street. So I own the house and the lot that directly abuts this parcel. And we're one of the abutters that sent you a letter back in December. And I appreciate this opportunity to speak directly to you. I'll have a couple thoughts. I'll do my best to keep it brief. But, you know, the core of our concern that we expressed in the letter is that we understand there to have been a local wetland on the site before the work was started, and that it appears to have been removed or significantly disturbed. Again, we're not suggesting it's on purpose or not, but I wanted to remind the commission that you have very specific and firsthand evidence from both David Haynes and also to a certain extent from Jeff Carlson, who inspected the site in person in 2020 before it was disturbed. And, you know, both of these men have kind of the technical expertise to assess whether there was a wetland there. And neither had any incentive to find one where there wasn't one, or to report something that was larger than the on the ground reality. And David was unequivocal that there was a wetland. He observed a number of indicators, including, I have to check my notes, swamp milkweed, moneywort, and box sedge. And Jeff Carlson also described his visit with David on the record on a couple occasions at your meetings. When we were before the commission for our renovation permit, which was in June of 2021, and then again at the time of enforcement. And we put direct quotations in our letter. I'll refer you there if you want to see them. And Jeff is here, so he can also speak for himself. But he also, you know, indicated that there obviously the cattails, jewelweed, and that he had seen hydric soils as well. Anyway, all that to say, you know, between the statements from these experts and the photos, at least the photos we sent were dated kind of in the 2020, 2021 time period. You have pretty solid information about where the wetland was and what was growing in it before the site was disturbed. And we appreciate the revised plan, but we are concerned that it doesn't recognize or attempt to restore the wetland, and would eliminate the buffer zones that the previous wetland would carry with it. And we ask that the commission, you know, the only reason you can't go out there today and see what Mr. Carlson and Mr. Haynes did is because the site's been disturbed. And so we ask you not to grant the benefit of the doubt to the party that created the confusion in the first place, even unwittingly. And I guess the last thing I just wanted to say is that, you know, if someone were to, it seems that if someone were to apply to this commission to dig up a wetland and install a rain garden, it seems unlikely that that would be something you would approve. And so it stands to reason that starting that work without a permit shouldn't cause the commission to respond more favorably to such a proposal. So just to kind of wrap up, we believe that the most appropriate path forward is a restoration of the prior wetland to using the photographic and other evidence, you know, basically the statements from Mr. Haynes and Mr. Carlson, there was a sketch and there are photos and there are aerial photos from the old site, real estate listings. There's quite a bit to go on about the earlier condition. And you will know the site's been restored when an expert of your choosing visits the site and finds a wetland with the same plant species, the same location, size, shape, general hydrology described by the experts that saw it beforehand. And until that's happened, we ask you to kind of keep the work stopped at the site and to consider all development in the surrounding area, including but not limited to that property, including us, in light of the applicable buffers. So thanks very much for the opportunity.
Thank you. Michelle Hunton, I see your hand up.
Hi, Chair, if I can please speak. I'm here on behalf of the applicant, Dwayne Jones, as well, from Rubin and Redmond. I just wanted to respond to a couple of comments, particularly recent ones that have stated that Haynes and now the commission have found evidence of hydric soils. From my review of the Haynes letter, I know there were statements in that letter that there was a belief of hydric soils. I haven't seen any actual evidence of that or documentation of sampling and results from that. We also haven't seen anything specific from the commission from the recent site visit. And I just wanted to remind the commission that the applicant's consultant, Kevin Garneau, did do actual sampling, soil sampling, and in a couple of letters he submitted, he indicated that the soil test pits, the soil matrix color and chroma do not support a finding of hydric soils. And as the commission knows, the wetlands policy 95.1 for delineation of BVWs does state that when there's a disturbed site, as Commissioner Seth mentioned, soils can be the sole criteria, but I haven't seen any actual soil sampling other than that from Kevin Garneau. I've seen, groundwater testing as to the depth, but not actually a review of the soil conditions. And the wetlands policy also indicates that looking at hydrology alone on disturbed sites is not always possible because it can vary from season to season. And, in this case, there's been a lot of recent precipitation. It's the winter season. And I think the time of year does, may affect the site. And again, just to reiterate what Art Gasborough said, the site conditions being at a low elevation and surrounded by a lot of other properties where there has been some construction going on have definitely affect the current conditions on the site. And I think, again, also the commission should be somewhat, thinking of the fact that I know the focus is just on this project, but there are a lot of other recent projects permitted that were within the area of this, alleged wetland, and, it wasn't found to be in a buffer zone. That's all I have to say for now. Thanks.
Thank you. I don't think that the commission demonstrated hydric soils. I could be wrong in how I heard that at the beginning, but it's the high groundwater coupled with the plant evidence, and those two criteria can qualify a wetland. You need 2 out of the 3. So, from my perspective, I think we maybe need more information. The site might need to sit to see if those iris species actually grow, to see if we get these wetland plants, and maybe to do groundwater testing a few different times throughout the year so we can really nail this down, because we definitely have some contradictory statements. And, the most recent groundwater did demonstrate that it could classify this as a wetland. So I think that's important for us to think about. Seth, go ahead. And then David, I see your hand up.
Thank you, Madam Chair. And I agree with your suggestion. Nothing in my comments is meant to attack the credibility of Mr. Garneau or Mr. Garneau's testing. I understand it was done in a different season, probably with a slightly different methodology. And I would like us to, if possible, to wait into the growing season and to take additional hydrology and additional soils and additional vegetation information so we have a better sense of what's going on site. That being said, since the application is before us right now, we either have to get a willing continuance from the applicant to wait till then, or we have to deny this current project and on the information we have, and then they can come back in the future if information changes. The first route is certainly preferable in terms of, the process. And I would just also point back a little bit to the history of what's happened on site. It doesn't really matter if any of the activities were intentional or not, but there was unpermitted work on this site that led to an enforcement order. That enforcement order from my recollection, was never carried through because it led to a application of notice of intent on this property that was then withdrawn prior to the commissioner changeover, so that there would be a suitable amount of commissioners who had actually sat on this project to then be resubmitted after the commissioner changeover, which it then was resubmitted. And maybe we shouldn't have allowed the withdrawal if we had thought about this a little bit ahead of time. But essentially, the current notice of intent might not be directly caused by the enforcement process, but is certainly a result of the enforcement process. We're here because unpermitted work occurred. So I think, we have good historical information about what I'm going to call extremely high likelihood of an isolated vegetated wetland on site historically in 2020 and before. We have a good indication that wetland conditions may still exist on site on the basis of our groundwater. And if we're willing to wait until the growing season, I believe we will find wetland vegetation on site as well. But given all that, I think our best course of action would be to try to wait, but we're sort of in a process where we may not be allowed to do that based on what the applicant would like to do. Thank you.
Thank you, Seth. David, your hand has been up.
Yes, please. Just to try to clear up some things, I looked at the site before the site was disturbed. It was in its natural state. That's been stated. There was a lot of trash there. It was about 98% lawn with a shrub line along the 15-meter street that I did see some debris in there, but the rest of the site was mowed. It was in its basically more or less in a natural state. It was not disturbed. I looked at it. I did look at soils. I always look at soils. I got 4 augers. They're all bent from. You guys don't have a lot of rocks, but I got a lot of rocks. And I did see hydric soils. I did not take this any further because the client did not want to go any further, because I did meet with Jeff. We looked at it. We looked at the soils. We looked at the vegetation at that time. And at that time also, it was before any work was done on the Kim's property with any drainage. There was no additional, the drainage hasn't been altered. Also on the Kim's property, the work that was done is no new impervious surface. It did have downspouts before. The downspouts are now discharging to it. What Ben Shampoo is putting in as a rain garden. But anyway, that drainage was no drainage was coming in from that property any more than what's already there. And I just wanted to point out that right now, what you're seeing is a site that's been extremely disturbed. It was dug up, bulldozed, pushed around. Right now, I remember it sloping down from the road to a low spot in the rear of the property. You look at the elevation on Art's plans, there's areas in the back that are higher than the front of the property. That isn't the way I remember it. I think there's been a lot of alteration that's happened there and changing of elevations. I'm not saying it's been filled, but it's been moved from one part to another or whatever. And so that would change the water levels that you would see. And I just wanted to try to clarify that point. Thank you very much.
Thank you, David. Jeff, I see your hand up.
All right, I'll take my turn now. I know I was going to talk a while ago, but it's helpful to hear everyone's context, and always nice to get to hear your name a lot. So that's always fun. I'm not going to disagree that David and I were on the site and looked at some things, and definitely saw some questionable soils and some soils that at the time probably even agreed exhibited characteristics of hydric soils. And definitely have seen cattails and reed on that lot and jewelweed and those fun things. But I think we're in a situation where I agree a little bit with everybody here, and kind of from a staff perspective. And it's one that we've looked for some comparables, whether we've had issues like this on island before, or even some guidance from elsewhere. And we're stuck in a little bit of a quandary where the site that was there previously clearly is never going to be what it was before it was disturbed. And I think that's the known quantity here, and looking at groundwater elevations and things that are there, I think is important. But I do think thinking about it too, and in these areas, and kind of I can't believe I'm going to compare it to this site, but it's eerily reminiscent of some of the work that we did over at 2 North Beach Street and 65 and 67 Easton Street, where you're looking at a highly disturbed site in kind of the same relative elevation. And what we even see on these sites for groundwater includes, some level of, even tidal fluctuation in groundwater that's there. And you're trying to fit that groundwater lens in between here and the ocean, which is not too far away. And then you're also looking at a site where, and this is really kind of the unfortunate piece of information that we're really missing and that photos can't capture, is what the site elevations were prior to disturbance and what the depth of the groundwater is for real. Because I think we know that, I think we can clearly see from where, landscape timbers are and some of that excavation and some of the topsoil removal, that there's definitely a depth that's been removed, and we'll never necessarily know whether it was an inch, 3 inches, 4 inches. And obviously we're dealing with those. So I think we're, kind of as we reviewed it and looked at comparable, we're left a little bit is, when we look at the bylaws and the definitions, is really what they're all getting to at the same time, is what the form and function of these resource areas are, and what they can be. And I think at the end of the day, it's kind of important to get something back in functional that's, kind of providing that same function that resource area provides, and provides, the things that the interests are protecting, whether it's a habitat interest or a flood control interest or erosion control interest or groundwater protection or whatever it chooses to be under the local bylaw, is getting that back in working order. And I think I understand waiting. We've done it on sites before with groundwater monitoring and wells and things like that. I think our concern from a staff level here is we're dealing with a site that's already extremely embattled with disturbance. Is letting it restore as it sits on the ground and letting it sit is still not in compliance with what was originally there. And I think, from a staff level, I think that, restoring some level of, wetland vegetation and infiltration services that those wetlands provide, and some sort of water handling that's there, plus restabilizing a site back to what were as close to pre-existing elevations as before, and then continuing to evaluate the site moving forward, is important to do. Because I think if you simply say, we're going to walk away from the site right now, well, we're no better than where we were when the violation occurred. And we have to carve some sort of path forward to deal with it. And I think that what's being proposed, while not a perfect solution, obviously, because we'll never know for sure what it was. I think putting an area that's providing those wetland functions back with the wetland vegetation, continuing to monitor that site, monitoring groundwater and doing that, and then bringing the site back to what was as close to original surface as possible and continuing to monitor it, I think at least gets us in a direction where a site's in better compliance than it was. I know that's not ideal. I mean, I know we've looked at the information that Mr. Garneau provided, and we don't disagree with that. I know the auger holes that Will and I went back out and did on Tuesday. We found groundwater, in similar positions, but we also, in a couple of the auger holes that we did, brought up after the first 4 inches of soil. There was one hole we brought up almost 8 inches of what I would call just clean stone, just little gray stone on that site. I mean, it's clearly, to me, a site that was, I hate to say it this way, but a classic downtown dumping site, probably over time, where you see bricks and gravel and landscape debris throughout and mixed in. I mean, it's clearly a site that's been filled over time and dumped on over time, and that's not justification for anything. But I think from our end, getting something in to restore some of those functions and continuing to evaluate is important. And, I think from my personal opinion, I think what's being proposed to restore some of that wetland vegetation and topography in there is appealing to get moving in the right direction. But then I think monitoring that area going forward and, kind of conditioning, monitoring, and even in finding groundwater, I think is something that can certainly be done through the permit to get the rest of that information that gets a site that's better than what it is today. I'm happy to, answer any questions on my thoughts, but at some point we have to make progress to get a site back to closer to compliance than what it is right now.
Thank you, Jeff. Any questions or comments? Seth? And then Art, I saw your hand up.
I'll try to be brief. The first is just a reminder that, obviously we're talking about a disturbed site. It probably was a historically disturbed site, but there is documentation of vegetative communities from photographs that are, I would say, significantly different than what's being proposed on the plan. So even if we don't want to go to the extent to specifically delineate this as a vegetative wetland, we should certainly require that the project applicant plant more appropriate species than what's being provided. And I love Clethra and I like hybrid blueberry too, but it's not reminiscent. We're talking about getting the site back into compliance with historical conditions. It's not reminiscent of what was there. We should have them planting the species that were there before. And many of these species are available in the horticultural trade. So I think that should be a primary step if we're going to move forward. And I think the last thing I'll say is that it's clear this is an odd site. It certainly doesn't meet the classification of a wetland under the Wetland Protection Act. And because of that, it was never delineated. But in our Nantucket local regulations, we have no requirement that we only protect delineated wetlands. We protect any wetland that the evidence points to being a wetland. So if a historic delineation didn't exist, it doesn't prevent us from creating a delineation now. Thank you.
Thank you, Seth. Art, your hand had been up. Do you want Linda to go first, or would you like to go? Linda?
I'll certainly defer to a commissioner.
Okay. Linda, go ahead.
I appreciate what Seth has said. I appreciate what Jeff has said. What's the end game? What is Jeff suggesting that we do as far as a vote to sort of go along with what Jeff suggested that we need to do? What exactly does that, how does that translate into action today? That's just what I'm seeking clarification on. Through you, Madam Chair.
Yes. Well, Jeff can speak for himself. My read on it was that the current plan by the applicant to have a rain garden back there to try and get infiltration and plantings back in would be a good step towards restoring the site, is like a paraphrase versus just leaving it fallow.
Hanging.
To,
Yeah. All right, but the appropriate plants can be worked out through staff?
well, we could condition that, or Art and the applicants could agree to that tonight before we close. We haven't closed yet, so.
Okay, I'm just wondering, I just didn't know where I was going, and I have some clarity now.
Awesome. Thank you, Linda. Jeff, I see your hand up. Art, would you like Jeff to speak before you go?
I guess I'll just say what I was going to say, and that is that we certainly, honestly, I came up with the plants, and we can work with staff to modify the plants. I thought the wet mix might have some of that already in there. There's a lot of variety, and you might notice that I called for that seed mix to also go up around the shrub plants, but we could certainly, work with staff to, change the actual planting list that would go around that area if that was sort of the concern. And I would point out that, Mr. Haynes made a great point that, 98% of this lot was lawn. It's really that, kind of back small corner where that one picture was taken. And we've proposed to greatly enhance this rain and enlarge this rain garden that would go to, some 350 square feet across the whole, and really to make it to function better in terms of the land subject to coastal storm flowage resource area. And I wanted to point out that, there's been this talk of unpermitted activity. And again, we understand and agree to that with respect to land subject to coastal storm flowage. The owner had never heard of such a thing. And I think that, most of us all know it, but there's plenty of folks on the island that would not be aware of that particular resource area. And, I will bring back that there was, permitting done 5-6 feet away for structures from this area that's being considered, and told, to us now that it is a wetland, that someone comes in here and wouldn't expect that would be considered a wetland when, there was buildings that were just put up fairly recently, immediately adjacent to that area. So I do think that it's, needs to be taken in context in terms of, the level of or expectation or wording of unpermitted activity. He understands it with respect to the didn't know about the land subject to coastal storm flowage. And I do think that, going to a 350 square foot, much larger area will function much better, be an overall improvement, get this site put back together, and then we can move on from there, and we could certainly adjust the plants if that would be helpful. Thank you.
Thank you, Art. Jeff, I'd like to go to you, and then I'll go to RJ.
Sure, and again, I think we're always happy to work on plant lists. I know in our review a little bit, we talked about that. Obviously, there were some cattails there before. I think as the site currently sits, I think cattails will have some difficulty. I mean, they're pretty rugged, but I think they will need a little help ground wise to get going. But I think they could certainly be added in, especially to some of that mix. And I know in a lot of cases, the commission has liked some level of shrubs just to help delineate and keep people out of those areas where it's, you're more herbaceous and vegetation don't want to get mowed or anything incidentally. I do think it does present an opportunity though. Excuse me, I'm gonna choke on myself. When we look at it, is there may also be opportunity, right, to collect some data on this area as we go. Right. I think that even if the permit included a finding that, in some conditioning where, we did something to monitor groundwater within those areas and the areas primarily of concern, and take data and get some at least, regular reporting. Groundwater data is not hard to get. I mean, you can install a small monitoring well and put a ruler in and measure and get regular data that a good finding can determine that, the rain garden area as being shown, is as permitted, any future application on the site will have to provide the groundwater data for this area. And you could even set up another one on the site to determine where it is, to determine the extent of any potential future resource areas that are there. And then as the site's, managed and monitored, if something comes back in future permits, we have the information that we need. But in the interim, you have a site that's not a mess and something that's functional, right? Is I think gathering data and compromising to restore a site don't have to be exclusive. They can kind of work together. And I think that's what we're all pointed towards is we wanted to sit and do those things, but I think we need to give some instruction and some guidance on how it should sit. And I think that's where what they put forward with some, maybe some adjustments or some additions to those planting lists, and then a little bit of data collection with it, you can get all that information. And then any work on that site, any work, I'm just going to say it, and I think everyone knows to be clear, whether it's a structure, whether it's a new landscaping feature, a new driveway or parking area, any of those things, even just the presence alone with the entire lot in the flood zone, still are going to require additional filings to do. And I think everybody that's on the meeting now understands that this is a site that requires permitting for any work to happen. So I think setting up to be able to collect information in a reasonable way and evaluate the site after it's been put back to some level of original condition and reserving the right to, make some determinations later, I think sets a good path forward. And I wish we could rewind the clock and go through it all and delineate and do those things, but we can't. So I think we're doing it, and to bring out my inner Midwestern as much as possible, I think we're a little bit of making, lemonade with the lemons here and trying our best to get data and get a site back into compliance. So I think to answer Linda's question, our recommendation is to get the site back with some tweaks to the planting list and a couple spots on the site to collect some groundwater data, and then, revisiting the site in any future permit applications. I mean, right now it's for a pervious surface and essentially a constructed rain garden or whatever it will turn out to be. I think that's a pretty prudent way to move forward.
Thank you, Jeff. RJ, I see your hand up.
Thank you. Can I request some clarification on what was originally required with that enforcement order from 2022? Was it just a cease and desist? Thank you.
I believe it was a cease and desist and to come back with a notice, but I do not have that in front of me. I don't know if Jeff or Will can speak directly to that.
I do. I actually have it right with me here. This is one where, of course, when I switched back to Zoom, my window disappeared. We issued the cease and desist. I have a computer navigating issues. And then the only instructions that were there was requiring the applicant to appear before the commission to begin discussion on how to remedy the violation. So there wasn't any specific action that was given other than to stop. And then come see the commission to talk about how to fix it.
Seth?
Thank you, Madam Chair. So I understand from the current plan that the landscape timbers are proposed to be removed. And then there's some proposed fences. Are those still part of this application, the board and picket fences?
Art, go ahead.
Yes.
And given that we have the possibility of a wetland on site, but doesn't sound like we're gonna make that determination, would the applicant be willing to consider alternative like a split rail fence in that area?
I'll get back to you if that was to me through you, Madam Chair.
Perfect. Thanks, Art.
Any other questions or comments, Linda?
As to split rail fences are not allowed in the old historic district, period. Because they weren't typical in the old historic districts. Obviously, type 2 cap picket fences on the like are allowed in with an HDC approval. But if you're going to try putting a split rail up there, then that's going to have to go to the HDC, because the only way to get a split rail in the old historic district, which this is in the middle of, is to go to the HDC. So if you're going to planning on a split rail, which is probably the most amenable fence around it to keep people off it and nobody putting any more stuff on it, then you're going to just keep that in mind. You're going to have to go to the HDC for a split rail in the old historic district. But I personally think a split rail fence is better than a solid fence of a picket.
Thank you, Linda. Art, I see your hand up.
So to both commissioners' points, the applicant actually already has HDC approval for the fences that were proposed. We certainly could change that rear fence from a solid board to a picket so that we sort of meet in the middle, if that's helpful, where we can not get caught in a quandary with HDC, but also take away the board fence that might have been a concern to the commission.
Seth, go
Yeah,
ahead.
Madam Chair, I don't have a problem with any type of fence that they put in there. I just wanted to make sure that they got, if they're going to go to a split rail, if they're going to change the fence, then they got to go back. That's my only caution.
Thank you for that reminder. Seth, go ahead.
Yeah, I mean, I know we've been talking about this for a while, so we're talking about a fence, but a picket fence would be preferable because it's more permeable than a board fence. So if that's okay, I would appreciate it.
Certainly.
Thank you. Mark, I see your hand up.
Yes, thank you, Madam Chair. Are you ready for a motion to close the hearing? I'm prepared to give one.
I mean, I could have been ready. Yeah, yes. I want to make sure all the questions are sorted out and that we have, a clear plan for Art and his client as far as plants and fences, etc. But yes, I think we're hopefully getting close here.
I will so move.
All right. Is there? Art.
With Art's blessing.
Yeah.
Yes, ma'am.
I'll second that
Okay.
with Art's blessing.
Motion made by Mark, seconded by Linda. So by roll vote, Beal.
Yes, with the amended plan for the different fence.
Okay.
Yeah, aye.
Engelborg.
Aye.
Arisman, aye. Golding.
Aye.
Mizzarelli.
Aye.
Landowski. Oh, you're muted, Joe.
Aye.
Williams.
Aye.
All right, that carries unanimously. And I really appreciate everybody's participation on this one. It's one of the more complicated sites that we've dealt with. So again, I appreciate everybody sticking with us.
I think Ian is here now. I think I just saw him somewhere.
Yeah, Ian's been on. He came, his video
Okay.
came up. Yeah, so he's similar to you tonight, that he's mostly just the name screen.
I did see his picture for a second.
Yeah, for the vote. All right, so that moves us on to Nantucket Island's Land Bank at 17 Aurora Way. I know we have Rachel Freeman on for this one.
Thank you, Madam Chair. My name is Rachel Freeman, and I'm here representing the Nantucket Islands Land Bank tonight with a notice of intent application before you for a boardwalk at 17 Aurora Way. This is an application we began with a hearing last year and then withdrew and are reapplying. During that period of time, we did due diligence regarding this site and discovered that this property was actually given to the land bank in 2002 as a component of the open space for the subdivision in Aurora Way. And it's a 4.61 acre property and has, is that our plan? That's an adjacent plan, but that's okay. We can roll with it. It has that's 15 Aurora, right? We need 17.
Yeah, I believe that was the clearest plan that was in our packet.
Okay.
Actually.
Okay, fair enough. Okay, so sorry about that. The subdivision on Aurora Way was granted a special permit in 2002. And as a part of the condition of the special permit, this 4.61 acres of open space was set aside to mitigate density and basically enhance the experience that people that live in the vicinity of the development. It's called out specifically in the special permit that preserving this parcel as open space maintains its current ecological integrity and preserves the ability of future residents and neighbors to utilize the land for berry picking and other passive recreational activities. There's also declarations of restrictions and easements, or declaration of easements and restrictions that clearly call out public access as well. In order to access this property at this point, it is necessary to use the designated access that was determined in the special permit and during this development of the subdivision, which goes directly through a wetland. Prior to this time, the property at 15 Aurora Way was not developed, and everyone accessed the site casually through that property. Since that has now been developed, there is no actual access without going through the wetland, and that wetland site leads to a berm and a trail that has been in existence for many, many, many years now, dating back to in the 60s or even earlier. We did due diligence as well on potentially looking to see if there was easements we could get with the neighbors. The commission requested that, we look at land swaps and a lot of different alternatives. We did due diligence on those, and first of all, it's not possible for the land bank to swap land, and without 2/3 majority vote at the legislature. And it is also the neighbor next door is not interested in providing us an access easement across their property. With that in mind, we went back to look at the boardwalk that's necessary and is required as a public passage over a wetland. And we looked at the site and had it staked and discovered that, it is possible for us to avoid having to remove a large willow on the site by wrapping the boardwalk around it. But that some pruning would be able to occur, but in general, that would be the way to mitigate, complete clearing of the vegetative wetland in that area where the boardwalk would be proposed. I am happy to answer any questions or to delve into the background of the subdivision plan if the commission would like me to do so, but I would like to open it up to find out what questions you have.
Thank you, Rachel. Mark, I see your hand up.
Yes, we tried to do a site visit on Monday and couldn't find the trail in. It was wild bush and then a pond. Can you help me with that, Rachel? Where do we go wrong? We went on Aurora Way, and by the development there's a new house being put up, and we were right close to that, and we ran into heavy undergrowth and couldn't get in.
It is pretty thick in the beginning. It's basically goes into a wetland, and that's the boardwalk. The trail is behind there. If you were to go through, like I said, if you went through 15 Aurora Way, where the trail used to go, that was how you access the trail behind.
Follow up, if I may, Ashley. I didn't see a plan for the boardwalk in my packet. Is it there? And I just didn't see it.
We didn't have one in our packet. We only had the neighboring property plan in our packet.
I want to see a plan for the boardwalk, please.
Oh, I'm sorry about that. I will make sure that gets to you.
Seth, I had seen your hand up.
Thank you, Madam Chair. I was also at the site visit, and for those who aren't, if you look in the packet at photo 6 that was submitted, that's very similar to the conditions that were on Monday. There's no chance of you walking into that property without waders on, so it's very wet, very shrubby. And although personally I feel like this is a huge missed opportunity for better open space coordination historically, there's nothing in our regulations that should prohibit this project. I think it squarely fits into the water dependent use, and could be permitted as such. Thank you.
Thank you, Seth. I unfortunately really cannot stomach this project. I'm concerned, and Rachel, you just mentioned part of the open space plan was for like ecological benefit. I'm worried that putting a boardwalk over the wetland diminishes that. I'm also concerned if this is a land bank project for the town, essentially, and the public, there needs to be a way for other members of the public to access this spot, and not just the neighbors who could kind of go out their backyard somewhere and access the trails. So I have trouble with this one and justifying the water dependent use here. Mark?
Yes, I just wanted to follow up. I had one more thought for Rachel. I don't see a linkage to other properties there. Does the path go to other properties? I know that's one of the land bank's major goals and with great success, but I don't seem to see it on this plan.
There's no linkage. This is just allowing people to access what is a public open space. One of our major concerns is actually that the special permit that was awarded by the planning board at this point would be completely out of compliance for the subdivision, and it would not be fulfilling the obligation of the subdivision open space that states in any number of ways, both in the deed, the declaration of restrictions and easements, and the special permit, that it's for public access. So if you can't publicly access the site, as you saw when you went there, because you can't access it without going through the wetlands, then we are completely out of compliance with the special permit, which sets an interesting precedent for subdivisions as a whole. Was this great planning to provide an open space component to the subdivision that required a wetland application access way? No, that was not good planning, but that's where we are today. And so I feel like that is why we are continuing to come back and request that this be granted and that we be allowed to do this.
Rachel, question for you. What percentage of the wetland will be covered with the boardwalk? I'm just kind of curious of like percent disturbance of that water area. And is there any way to mitigate that sort of disturbance elsewhere on this property?
So the boardwalk itself is 400 square feet. The wetland acreage in that area is completely unknown to me. It is acres of wetland, because if you actually proceed back behind that open space, what you end up in is additional open space for a subdivision on the other side, which is completely wetland. So you back up to that, which then goes over to Austin Farms. So there's 5 additional acres of wetland open space behind this property. And if I had to guess on this property alone, there's at least an acre of wetland. And then in the adjacent property, which I know at 14 Oak Hollow Lane, is also mostly wet. I would say that property is about 2/3 wet, which then goes over to Lake Sylvia. And the property at 14 Oak Hollow Lane is almost 7 acres. and most of it's under CR. It's privately held. So it's hard to say alone what the percentage on this property alone is without taking it within the context of the area as a whole, I would say.
Okay, it would just be good for my perspective on the disturbance, because again, I think I understand open space and access, but again, I have difficulty with this one. So I'd like more information about the overall site.
We could certainly do additional delineations on our own property, to fill out that network of wetlands. It's pretty extensive, but like I said, most of our property is actually, there's a fair amount of upland, but it's the surrounding properties that are exceedingly wet.
Well, yeah, it would be great to know, because for one, I love exploring wetlands. So if this is going to be open to the public, there should be a bike rack there so that I can go and the public can go explore this space. So I want to make sure that's a component here.
One option for that, if I may, is that actually the land bank also owns 1 and 2 Aurora Way, which are immediately adjacent to the bike path, and we would be happy to put bike racks there. There's also there's a public easement along Aurora Way itself, the road, to ensure that there's public access for people outside of the development. There will be no parking though, but we're happy to put bike racks in, definitely.
Yeah, I think that's an important, if it's truly public open space, that it's public open space.
Mm-hmm.
Linda, I see your hand up.
I just want to clarify something. I think I heard it earlier. When the land was given to the land bank, I've seen other conditions of land being given to the land bank, whether it's for this purpose or this purpose, obviously. Was this specifically given to the land bank for public access? Was that in the deed, that the conveyancing material to the land bank, that the public be allowed to access it for recreational purposes or some such thing like that?
Yes, basically, it says for both the deed or all the deed, the special permit, and the declaration of easements and restrictions all mention that this is for public access in some form or another, all relating to passive recreation, in terms of berry picking or walking and environmental reasons. Those are the two reasons that are referenced.
I didn't have a problem with this because of that for the first time, because if it's land bank property, it's for that purpose. I don't have a problem with you trying to access it. Obviously, the boardwalk is, I assume, elevated to some extent through there. And I don't have a problem with it. I didn't have a problem with it before, and I certainly don't have a problem with it now, especially if public access for the bike racks is up front and they just walk down Aurora Way. It's not that far on the sidewalk that they were forced to put in.
Thank you, Linda. Any other questions or comments from commissioners? Joe?
Just for clarification, you walk in on the boardwalk, and can you go any place, or do you have to go back out through the boardwalk?
You have to go back out through the boardwalk. Basically, you can enter the site. There's a nice stand of pines. There's a trail that's maintained through there, although it's not being maintained right now. And then it kind of opens up into a pine forest that's sort of similar, I guess, if I had to equate it to anywhere, would be a little bit in some of the open areas in the state forest, where you have kind of an open understory and pines up above, and pine needles on the ground. But it does not connect.
Thank you.
In part because of the wetlands.
Yes.
That surround it.
Great. Any other questions or comments from commissioners before I open it up to the public? Looks like no, so we'll open this one up for public comment.
Does not appear that we have any public comment on YouTube or on the Zoom call. So if there aren't any other questions, Will, do we have everything we would need to close?
Yes, indeed, we do.
Rachel, would you like to close?
Yes, please, unless Mr. Beal would like me to submit a plan of the boardwalk. We have a schematic for what the boardwalk would look like and dimensions, but we did not submit. You're correct, but we did not submit a specific plan.
Mark?
Just give me a clue as to how long it might be, Rachel, please.
Let me double check. Like I said, it's 400 square feet. It's 4 feet wide. I believe it's 100 feet long. So to get from out of the wetland resource area to out of the wetland resource area.
Okay, thank you.
Mm-hmm.
All right.
I'll make a motion to close the public hearing. Is that where we are now?
That's where we are. So Linda's made the motion. Is there a second? Seconded by Mike. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Harrisman, aye. Golding,
Aye.
Mazzarelli,
Aye.
Landowski,
Aye.
Williams.
Aye.
All right, that carries unanimously.
Thank you very much.
Thank you, Rachel. And that moves us on to Local Buoy Properties LLC at 15 Loretta Lane. Looks like we have Dan Malloy on for this one.
Good afternoon, Dan Malloy for the applicant. I think you had Mark Ritz down. I'm stepping in for him tonight. So we're before you tonight to essentially resuscitate an application that the commission had previously granted something almost identical to this back in 2009. And for whatever reason, the previous owner never acted on it. So what we have before you tonight, we're proposing to restructure or rebuild the existing. If anybody's been out there now, it's a roundhouse. It's a dodecagon. It's the first one. It's a 12-sided house. So the owners are looking to pull the house back, pull it outside the 25-foot buffer zone, reshape the house, do some slight expansions to it, while also raising it up a few inches out of the floodplain. That's the big picture of what's being proposed. If we can see it on the right side of your screens, has the blow up of the proposed plan. If easier for people to look at it. There we go. So you can see the 25-foot buffer zone in red. You can see the round shaped house behind it. And we're proposing to pull it away. And also square it off, essentially. We're trying to get as much of the house outside the 50-foot buffer zone as we can, while also honoring the building setback lines. From a wetland perspective, we have a coastal bank on the harbor side that's armored. And then we have a bordering vegetated wetland to the southwest and the south. We're not proposing any work outside what you're seeing on this plan. It's a pretty big property. We're only focused in this one portion of it. As part of the work, would take out the deck, essentially, like I said, take everything structure-wise outside the 25, try to pull it back. We're somewhat limited as to how far back we can go without encroaching on any other buffer zone. As you can see, there's a 25-foot buffer zone to our south as well. So we're trying to find a common ground, someplace we can pull this back, restructure it, and try to meet the performance standards as best we can. We are asking for 2 waivers. One of the waivers is work inside the 25-foot buffer zone to remove the structures that are there, take those out. And then a waiver to modify and expand a portion of the structure inside the 25 to 50. The property is already on a septic system and a well. We're not touching the utilities, not touching the septic. Those are all in compliance with the harbor watershed area, so no septic works required. Everything is strictly house related. Area-wise, I'm happy to go through all the individual square footages as to what's where, if you want to get to that detail. But we are obviously taking structure out of the 25. By reshaping it, there is a small increase of structure inside the 25 to 50. And with that, I'll answer questions.
Great. Thank you, Dan. Will, have you stopped the screen share?
Slow on the draw, sorry.
There we go. No, it's fine. The first time I lost my screen completely, which is why I was muted for so long. So I wasn't sure if it was me. Any questions or comments from commissioners? Seth, I'll go to you, and then Ian, I'll go to you.
Let Ian speak. I've spoke a lot already.
Okay, Ian, go ahead.
Thank you. So, Dan, is there any reason why you can't remove the rock revetment?
The rock revetment was put in, I saw the permit sometime in the last 10 years or so, I believe. And that's stabilizing the bank right now. So it's certainly not something we're looking to remove.
Well, I think from my perspective that in order to approve the expansion of the house and remove it back, I would want to see the rock revetment removed and have another form of stabilization in its place. So thank you, Ashley.
Thank you, Ian. Seth, go ahead.
Thank you, Madam Chair. I think if the applicant was willing to reconsider the material for the coastal bank, that'd be great. Moving from a rock revetment to a different solution would be ideal for that area. But in terms of my other comments, I was able to take a site visit out there on Monday. It's certainly a unique house. I know that's not our purview, but it will be sad to see it taken down if it does happen and is raised and rebuilt with something else. But in terms of wetland regulations, I certainly don't support any expansion to the structural area. I could support moving the structure back and elevating it only within the same square footage as currently exists on site. I also would like to say that it's my understanding from Nantucket GIS that the current structure is pre-78. Obviously, this one would not be, and we need to specifically make the appropriate findings to indicate that any new structures are not applicable to have coastal engineering structures provided to them given their post 78 status. So thank you.
Thank you, Seth. I knew that was going to be coming up at some point. Linda, I see your hand up.
Yeah, I knew that was coming up myself. The structure dates from 1970. I too know the structure and the rock revetment, which I don't believe got there until into the maybe 2014, somewhere in there. I just want to clarify, are we demolishing this structure and building a new one further away from the bank? Are we going to try to modify this thing? It's a great playhouse. Modify this thing, or are we just taking it out completely and building something much farther away from the bank? Through you, Madam Chair, to Dan.
It looked like the plan said it's to be removed, but Dan, will you clarify?
Yeah, the intention is to take the house out completely and build new.
Okay, much farther away from the bank, correct?
Not much.
Well, that's a question we can certainly work with the commission about. So we've pulled it back to the 25. We could go back a little more, but I don't want to start encroaching on another buffer zone behind us.
Well, I'd like to see it, pushed it as far back as you can get it. I'm appreciating the fact that it's coming away from the bank. On this side of Pacoma, it appears to be more erosion on this side of it than there is on the other side of it, or different type of erosion. As you get closer to the point, it really becomes much different. But I think if you move it back farther, as far away from the 25 as you can get, I don't really have an issue with it.
Thank you, Linda. This site is pretty dynamic. There's a marsh kind of on one side. There's a lot of groundwater kind of flow.
A lot of stuff going on. Yeah.
through the beach and like through the bluff. I actually take long walks on Pocomo and usually turn around past the site. So I'm very familiar with how it like performs during storms. And there
Yeah.
is kind of some end scour that goes on with that revetment that they have. I'm curious, Dan, you mentioned at the beginning, and I'm in agreement with Seth that we shouldn't have an increase in square area, but what are our totals here for changes within the 0 to 25 and changes within the 25 to 50?
All right, so we have a reduction inside the 0 to 25, a reduction of 151 square feet. In the 25 to 50, we have an increase of 311. And then outside the 50, we have an increase of 253.
Okay. Thank you. Any other questions or comments from commissioners at this point? Okay, so we will open this one up for public comment. RJ?
Thank you, Chair Erisman. I actually have a question related to the revetment and whether it was originally permitted across a property line there. That's not typically how it's done. Thank you.
Thank you, RJ. That's a good question. Dan, do you have anything in the permitting history?
We can look. We didn't do the original design and permitting on that, so I don't know how that was done. I know there are permits for it, but we can pull it out and look.
Okay. And we can probably track down on the natural resource end as well. That's a good question. Does not appear that we have any public comment on YouTube. Any other commissioners' questions or comments? I just want to make sure we give Mr. Malloy kind of what he needs to move forward. Great, it looks like no. So Dan, what would you like to do here?
Well, let me ask a general question first. So I'm hearing a little bit of both sides. So I'm hearing that some people aren't interested in expansion, and maybe some people are interested in trying to move it further back. And I guess, since not everybody had comments on this, I'm just wondering if we fall in the middle somewhere. We're going to continue, so I'd like to get a little more information on some of the history for you and see if we can't move this thing around a little bit. If we can get it further from the bank, and to see if we can make any modifications to the house to address some of the square footage concerns.
Yeah, I mean, I think, as much of the structure that you can put between the 50 and 100, the better. So, I would not like to see increased structure within the no build zone, so between the 0 and 50.
As an idea to throw out there, is something we'll work with, since we're taking away 151 in the 0 to 25. And obviously I can't hold you to it, but would there be some thought to allowing an increase in the 25 to 50 of that same square footage, so we can at least put it back?
Well, I think for me personally, yes, if it was a fair swap. So if in between the 25 and 50, we were up 151 square feet instead of 311 square feet, I think that would be a better situation from my perspective. I think other commissioners should weigh in. Linda?
That sounds reasonable, but this is an incredibly small structure because of its odd shape. And if they're going to try to build a dwelling that's actually going to accommodate humans, as opposed to this one, I'm not opposed to them increasing the ground cover outside of the 25 to get a reasonable, not a McMansion, let's put it that way, but something reasonable that they, can have a family in. This one is impossible at the moment. So I agree with you. The more I can get out of there, better off to me. Farther off I can get.
Dan, can I ask a clarifying question? I know this property is large. Is this the only structure on the property, or is it kind of an auxiliary right at the beach?
This is the only building on the property. I don't believe there's any other really I'm almost positive there's no other building space on the island, on this lot available.
Because I think.
If you,
Oh, go
yeah,
ahead.
if I was gonna say, if you looked at the overall plan again, there's a long dogleg that comes in off Loretta Lane where the driveway kind of twists and turns, and that's really, it's just a small 20-foot strip of land that it comes in between the two wetlands and you open up into this house. So there's really nothing else. There's no other place you could build in this property, and I don't see a situation where you'd ever see an application to propose anything else.
You know, the other thing I think we'd be looking for here is pretty detailed construction protocol, given the constraints of this site. Kind of that plan to come as part of this. Seth and then Ian.
Thank you, Madam Chair. I'm a bit confused by the plan because as I read it, the entirety of the proposed structure is within the 50-foot buffer to something, except for, well, maybe a little bit is outside the southeast corner, but almost the entirety is within the 50-foot buffer. And if you look at the current structure, it's 955 square feet. The proposed dwelling is 1,410. That's a significant increase. So I think if we could get closer to the same structural area that existed before, get as much out of it, out of the 50-foot buffer as possible, understanding that this isn't going to be a site where the entire structure could be outside the 50-foot buffer. That's what I'd be looking for. Thank you.
Thank you, Seth. Ian?
Yes, so I would urge my fellow commissioners to insist that the revetment be removed as part of this permitting process. It won't be entitled to pre-78 protection, and we know what's going to happen going forward, that it will end up being an isthmus. And if Jeff was on this call, I thought that we had number 17. We had a long discussion about the wetland there when 17 was being developed and trying to preserve the wetland there. So I would urge my fellow commissioners to consider this. And Dan, I would ask you to take this under advisement. Thank you.
Thank you, Ian. You know, that one would be one way to get at like the reduction in square footage within the resource areas and buffer zones would be to remove that revetment. So that could be one way to do it. It already is a little bit of like a peninsula effect, Ian, but with this one, the revetment is so short, it's actually going to undermine behind, and itself will be like an independent structure. It's I'm not sure if you were at the site visit. I was not, but I'm just familiar with the property. So
well, I'm not. So I'm saying that there would be choir rolls, that would be an alternative construction, not just taking it away and leaving it naked. So but I wasn't on the site visit, and I haven't been there for a couple of years.
Seth, I thought I saw your hand go up.
Yes, thank you, Madam Chair. I would just urge fellow commissioners who haven't been to the site to go there. It is a very dynamic site. The area to the east is extensive marsh. Even like getting up to where the driveway is, you're driving through a marsh basically with this small gravel driveway in between it. So it's a constrained site. But I think I've heard some ingenious ways of moving forward. And I think that changing from a stone revetment to a different type of coastal bank would be very ideal to the future of the wetland resources on site.
Thank you, Seth. Any other questions or comments? Mark?
Thank you, Ashley. I would just support the theory of moving all you can back out of the 25 and keeping the number of square feet the same. I think expanding it it's already a very tight area, and you're working with a waiver project. I think expanding it would not be. I would not be in favor of it.
Thank you, Mark. Dan, do you feel like you have everything you would need?
Yeah, I think we've heard from the commissioners, so we'd like to continue to the next meeting so we can look at some revisions.
Okay, our next meeting is February 16th.
Okay, that would work. Thank you.
All right, perfect. So we'll see you on the 16th. Okay, so that moves us on in our meeting. We have no amended orders, no RDAs. So that moves us to minor mods. We have Stones Throw LLC at 29C Old North Wharf, represented by Art Gasparo.
Thank you, Madam Chair. We're before you with a second minor modification for this project, which involves the maintenance dredging out at the end of Old North Wharf. And this is a further reduction in the permitted footprint. And as comes as a result of the eelgrass survey that we did with divers and modifying our footprint to both stay away from the eelgrass that we found along, that remnant pier that's out there. And I've also included with the request, the sign off that we finally received from the Division of Marine Fisheries as a result of this reduced footprint, and the exact numbers I put into the request for the reduction. So I think from the commission's perspective, this is makes sense as a minor mod, and again, reduces the scope of the work.
Thank you, Art. Are there any questions or comments from commissioners? Looks like no. Will, do we have everything we would need to issue the minor mod?
Yes, we do.
Art, I'm assuming you'd like us to issue tonight.
Yes, please.
Is there a motion to issue the minor mod? Motion made by Joe. Is there a second? Seconded by Mike. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Garrisman, aye. Golding,
Aye.
Zarelli,
Aye.
Landowski,
Aye.
Williams.
Aye.
That carries unanimously.
Thank you.
Thank you, Art. And that moves us to Sandiac LLC at 6 Sandy Drive,
And
represented
I
by.
am recused from this one, Madam Chair.
Okay, thank you, Linda.
Thank you very much. For the record, Brian Madden from LEC. This order was issued back in December 2021 for the reconstruction of a single-family dwelling on elevated pier supports within the flood zone, and increasing wetland structure setbacks and removing structure in the 25 and 50 foot to a bordering vegetated wetland system along the easterly property boundary. Following final HTC approval, there are some minor modifications that basically involve removing all structural components within the 25-foot buffer zone. You'll see on the back of the building, the rear steps and porch entry were inset to the dwelling. So now outside the 25-foot. On the left-hand image, you see the existing structure, and then on the right, we have the original approved footprint outlined in red for comparison purposes. The north addition has been reduced in size from 658 square feet down to 492. There's some minor realignment of the dwelling footprints with the reconstruction of the dwelling on a new pier foundation, some minor modifications to the front and side rear porch steps, removing the outdoor shower, and realigning the back patio outside the 25-foot buffer zone. But all the restoration revegetation areas remain the same as originally approved. And the project continues to result in a reduction in the 50-foot buffer zone by 159 square feet. So with that, I'll turn over to questions.
Thank you, Brian. Are there any questions or comments from commissioners? Looks like no. Will, do we have everything we would need to issue the minor mod?
Yes, we do.
Brian, I'm assuming you'd like us to issue?
Please.
Is there a motion to issue the minor mod? Motion made by Joe. Is there a second? Seconded by Mark. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, aye, Golding,
Aye.
Nizzarelli,
Aye.
Lewandowski.
Aye.
All right, that carries with Commissioner Williams recused.
Thanks so much.
Thank you, Brian. And that moves us on in the meeting. We don't have any certificates of compliance tonight, so that brings us to orders of conditions. And we're going to begin with Akhang 10 LLC at 21 Meter Street.
All right. Before we go over what's already here on the draft, just real quick. I know Art's still on the call. I was just wondering if he can clarify the topography of the site once the work is complete. I know the site plan says that the grade is going to be brought to match the property surrounding. Just as the rain garden sits right now, it may not work too well topographically. So if we can condition it, or if we're interpreting the map wrong, maybe, or just if Art's got anything to weigh in on that.
Art, go ahead.
Through you, Madam Chair. So the idea was that maybe it wasn't clear, but that, you know, if you were to take a string across the property from the grades that were shown on each side, that's what we would, you know, restore. So essentially that's what I was trying to convey or say. And then the rain garden, I showed the proposed contour and sort of the set down. I think that the intent could be interpreted that I showed a half foot, 6-inch depression. So that could certainly be worded to provide a 6-inch depressed stormwater swale, if that was helpful.
Thank you, Art, for clarifying. Will, was that helpful?
I think so.
Ashley, it's Mark Beal. I have a question when the time comes.
Yes, go ahead if you have a question.
It went on so long with this. Did we ever make a determination or a finding if there was or was not a wetland?
We did not make that finding.
Thank you.
I mean, we can call out a finding here that there was a potential wetland. That might be why Seth's hands up, so I'll give it over to him.
Thank you, Madam Chair. I would request that in additional findings, we say something to the extent of, given historical and current conditions on site, the soil hydrology and vegetation appears to meet characteristics of Nantucket's definitions for freshwater, marsh, and meadow. That's not a determination that vegetated wetland definitely exists on site, but it's just saying that it appears to have existed on site.
Are you going to cover that in the monitoring though?
I think in the monitoring wells, I have a comment related to that as well, that if we make that finding, then when we do the monitoring, we can say, should the monitoring information support the finding of a freshwater meadow or marsh on site, that may lead to a future delineation of this resource area.
And I'm definitely in favor of adding that finding. It doesn't like stop the applicant from doing what they've proposed, but it I'm really losing my words here tonight, but it solidifies for us our discussion and the fact that we do have evidence of that potential. Linda, I see your hand up.
I don't see Jeff on here anymore, but does that add just one more level of monitoring that would be appropriate as opposed to stopping them from doing what they want to do?
So the finding doesn't really like increase or decrease monitoring, but that finding allows our monitoring to tie to something. Like it gives reasoning behind that monitoring. And then if the monitoring does show us evidence of changes or a wetland, we've based that off of a commission finding.
But that wouldn't stop them from coming back to improve the property with a structure or anything. I don't want to prejudice anything.
Any property owner can apply for whatever they want. You know, they could apply for a house on the beach. We're likely to say no to that. But
Yeah.
they, can come in and apply, and they will be heard fairly like every other application.
Just want to make sure that we're not, by doing this particular decision, isn't precluding anybody from ever coming back here negatively.
No, it would not.
Okay. Okay.
Just if I may, if we put in permit overview that there's a isolated vegetated wetland on site, that's an actual finding by the commission that currently today that resource area exists. If we put additional finding that there's historic evidence of characteristics of these types of habitats, it means that we have suspicion that these habitats existed, but maybe not definitive proof. And the point of that is to allow our monitoring to prove or disprove the existence of those resource areas.
I'm not wild about that, Seth. I think it's sort of creating you're guilty until proven innocent. If you owned a property like that with that caveat hanging over it, I think I'd be a nervous wreck. I could always say, well, now 5 years from now, they're going to determine that there's a wetland there. I'm sort of troubled by that. I think we beat it to death at the hearing. I think we should either say it is there or it's not there.
So Mark, I think that's the thing. We don't have the evidence to say that it is there. The finding brings to light our discussion. If we don't make this finding, it's like the discussion went away. And I think it's important to make the finding because the discussion took place. We just can't wait long enough to determine if there's an actual wetland. Like I've asked Jeff before to put findings like that there's value in the wildlife habitat next door, just again, solidifying our conversation. And I do think it's important with this one, given the disturbance on site, to kind of memorialize that.
Okay, thank you.
Linda, I see your hand up.
I think Mark said it better than I did. I think Jeff had the proper language, and I think he was talking about the monitoring, et cetera, as Jeff explained it, which would not need this language inserted in this. So I'm having trouble with the language like Mark is.
Okay, Will, I see your hand up.
So I was just going to say my staff comment, I guess, is that as this finding currently sits, there's nothing saying that there's not another resource area present. And then with the additional monitoring, I think that gives us the opportunity to change that determination if the conditions change.
Which would mean, Madam Chair, just to clarify that, which would mean we don't need this finding that Seth suggested. Is that correct through you, Madam Chair, to Will?
So
I was just essentially saying that I think that we have the same function of, we have the same function in this as written, if we, whether or not we include that, because I think the door is still open for that possibility with the monitoring.
So I would like to hear from all commissioners on this finding, because honestly, we put in findings like this before, not to inform on future applications, but to memorialize the discussion that took place. And I, you know, again, I feel like it's important to memorialize this here, given the dynamics of this situation. Ian?
Yes, I agree with you, Ashley.
Thank you, Ian.
But Mark, I don't see why it's holding, you know, holding a loaded gun to a, if I may use that expression, to an owner's head. I think it's just, you know, trying to find out what the situation really is going forward with, you know, since we've had Jeff and the testimony from every party. So thank you.
Thank you, Ian.
I mean, I feel good I feel okay about it as long as we're continuing to monitor going forward. I guess I don't feel strongly either. Well, I shouldn't say that, but I feel that we're improving the site with what we came up with tonight, and we're going to continue to monitor it to see what findings we come up with in the future. That's okay by me. That's just my comments. Thank you.
Thank you, Mike. Because again, making this finding ties our monitoring to something, because we wouldn't normally require some of this monitoring if we didn't have these questions in the first place. Joe, I saw your hand up, and then Seth, I'll go to you.
Yes, you were looking for a comment. My comment is, when I got done listening to the hour or so that we talked about it, I was just on the fence. I wasn't leaning one way or another. What happened, as I looked at it, what was happening in prior years may not be the case of what's happening this year, today, now, or this summer. I didn't hear a convincing argument one way or another. I heard one side, I heard the other side, and where was I? I was right in the middle.
That's crazy.
Okay. So, I mean, honestly, from my perspective, in 9 years on the commission, we should err on the side of caution and put this finding in as additional findings. Again, it ties our monitoring to our discussion. Seth, I think I saw your hand up again.
Thank you, Madam Chair. And I am highly in support of that, to the extent that if we don't put this finding in, I'm going to vote opposed to this order of conditions. Thank you.
Thank you, Seth. So I think we should put the finding in,
Yeah.
honestly.
I'd like to word this correctly. Also, I do want to clarify, I have nothing against this additional finding. I just wanted to make the point that we still have the ability to look at the site, luckily. But would we want to say something like the commission finds that the historical photographic evidence on the site showing wetland species along with soil hydrology that has been observed, something like that?
Yeah, I think the commission finds, based on, you know, the historic photos and evidence, more recent groundwater.
And expert testimony.
I'd stop a little short of that.
I'm not going there.
Okay.
Photographic evidence, evidence taken by staff and at the site visit. Because you guys did, God, God, I'm sorry, I'm really losing my words tonight. You
Me
guys
too.
tested depth to groundwater at the site visit, and Will, you went back out with Jeff as staff. And again, it just showed some discrepancy that you wouldn't put that in, but the commission finds indicating high water that there is the potential of a freshwater marsh and or meadow. Was that what you were going for, Seth?
Yeah, I would say that there are characteristics indicative of freshwater meadows or marshes. Marshes and or meadows existing on site.
Please proofread that. I'm not feeling good about my use of the English language this evening.
Commission finds it based on evidence. And where are we addressing the future monitoring?
So
that
that
would be a
is,
condition.
yeah. And I can read these out if anybody wants.
I'm working with one screen today, so I'm sorry to be slow.
That's okay. It is small on my screen too. So maybe just going through generally what they say, Will, would be good.
Yep. So we have our 18, 19, and then 20 is all restoration plantings are to be native species with no cultivars. The rain garden shall also include a native typha species. 21, the applicant shall install a minimum of 3 monitoring wells and record groundwater levels on a seasonal basis with that information provided to the commission for review. The final location of the wells shall be reviewed and approved by commission staff. 22, all fencing shall be picket fencing or split rail fencing. 23, applicants shall provide photographs of the site at the beginning and end of the growing season with photos specific of the rain garden. 24, any invasive species found on the site shall be removed using best management practices.
Thank you, Will. Seth, I see your hand up.
Yes, I would respectfully request that we amend condition 20 to just say at the end, a final planting plan for the rain garden shall be submitted to commission staff for review.
Thank you, Seth. Any other amendments? Looks like no. So at this point, would somebody like to make a motion to issue as amended?
Madam Chair, I'm sorry, Madam Chair, is it possible for me to make a statement?
No.
Yeah, we're kind of done with that piece. What kind of statement are you trying to make?
I just wanted to say that I agreed with what Will said previously, that the finding number 3 does not, regarding that the only resource area is land subject to coastal storm flowage, I don't think prevents the commission in the future from making a finding that there's another resource area. And I think the monitoring addresses that. I do think that the finding number 4 isn't actually a finding.
Okay, so thank you. I think that's more than we would like allow at this point in time. But thank you. As that public comment has closed. Okay, had someone made a motion on that one?
I did.
Okay, so Linda made the motion. Is there a second? Seconded by
Mike.
Mike. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, aye. Golding,
Aye.
Zarelli,
Aye.
Kandowski. Oh, you're muted.
Aye.
Williams.
Aye.
All right, that carries unanimously. And that moves us on to Nantucket Islands Land Bank at 17 Aurora Way.
Alrighty. This one, we have 18 and 19. And then I added a condition 20, the land bank shall provide bike racks either at the entrance to Aurora Way on its parcels adjacent to the bike path or at the entrance to the trail system.
We might need to tie that, like to allow public access to the resource area or something along those lines.
Encourage public access, maybe.
Ian, I see your hand up.
Yeah, so when Mark said that he wanted to actually see a plan of where it was going to go, which sort of disappeared into the ether, can't we say that we need to have a drawing showing where it actually is?
I mean, we could have the final plan approved, come back
Yeah,
for, I mean,
absolutely.
Rachel did like waiver on a continuance for that, and then Mark asked the length and it kind of went away. So I don't think it was completely ignored, but at the end kind of slowly disappeared.
Right.
We can just say that prior to construction, a final boardwalk plan shall be submitted to the commission for review.
Thank you.
Hey.
Ding, ding.
So I missed the field viewing because I've been away all week, but based on Mark and Seth's comments on how difficult it was to find the access to the site, do we need to, just don't want people going willy-nilly. Do we need to ask for some signage? I don't exactly know how to express what I'm looking for there, but if it was,
I think I get what you're saying.
That's a good question. I know the land bank has actually been putting up like very recently really nice trail maps at all of their like property entrances. I wonder if one would be planned for here just to show that people have to make a loop and come out the same way and are not like branching out into other wetland areas or properties.
yeah, I'm just concerned with, branching out or trash ending up in areas that it doesn't need to be because it wasn't clearly labeled.
I think that's fine. I will just say, having been at the site, that once the boardwalk is built, I think it'll be highly visible from the road. So there won't be concerns about how to access. It'll be obvious. But
Yeah, I defer.
always
I defer
wants
to
signage and education.
Yeah, I defer to the commissioners that saw it.
They always put something up showing it.
All right, so Will's probably going to be doing his first minute, so let's not talk over each other because that is going to be brutal.
He's gonna love it.
You have to remind me, Ashley.
I love it.
I guess my concern is this is, and I hate to put this on the record, but this is a private park for the neighborhood. I mean, the close neighborhood. 4 or 5 houses in Aurora Way. It's not going to get used by the public. You know that. I think it's just because of the subdivision that they approved that we're being held, our feet are being held to the fire. I don't much care for it, and without a waiver, it's hard to vote no.
But why? What would stop the public from? I'm sorry. What would stop the public from going into it? I'm pretty interested to ride my bike and go check it out.
I think nothing would, Michael, but stay out of the way.
I think people just wouldn't know it exists, and then without an actual parking spot, it's more difficult. But I agree. I'll pedal there in the summer and go explore. They think those blueberries are just for the neighborhood. Land bank public.
Little do they know.
To circle back on discussion from public comment, the Conservation Commission, one of our roles is to provide outreach to the public on open space. So everybody tell your friends and family and community members about this awesome new access and hype it up.
Okay. In that case, I feel a little better about the signage.
Yeah.
I give up.
All right. Any other questions, comments, amendments to this one?
Are we happy with that 2022 or?
Looks good to me.
I think that's good.
Yep.
Yeah. All right, so is somebody ready to make a motion to issue as amended?
I'll make the motion, Ashley.
I'll second.
All right, I'm gonna give Ian the second because I saw his hand up there, but was hearing Mark first. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, I, Golding,
Aye.
Mizzarelli,
Aye.
Landowski. Oh, you're muted, Joe.
Aye.
Williams.
Aye.
And Joe, I appreciate that you're always muted because it means you mute in between and you don't end up like having feedback and things. So it's a good thing in many ways.
I understand.
Um, muted. I know, I'm doing it now. So we have no extension orders. That brings us to other business, approval of minutes from January 19th, 2022. Ian?
Yes, so for the Gully Road minutes right at the end, with the motion to consult with town council about pressing charges.
Oh, yeah.
And so it says carried 6-0, but then it says Plandowski, Arisman, and Engelborg, nay. So I think that needs to be corrected.
Yeah, because we had two votes. The first was to
Right.
actually press charges, and then that was a
Right.
3-3 vote. And the second vote that went through was to just consult with town council about like the consequences or something
Right.
along those lines of pursuing charges.
Yeah,
And that was the 6-0. Nice catch, Ian.
thank you. And
Anything
so
else?
and that actually goes down a second time, right at the end, the motion to allow the applicant to remove debris. And it again is carried 6-0. And then the Plandowski, Arisman, Engelborg, nay. So I think the cut and paste must have gone AWOL on that one.
Okay. Good, again, good catches. Anything else in the minutes? I shed a tear for Terry's last minutes for
I
us.
know, I know.
And Will is like cursing the world instead of shedding tears. Would somebody like to make a motion to approve the minutes as amended?
Motion to approve as amended.
Motion made by Mike, seconded by Joe. So by roll vote, Beal,
Aye.
Engelborg,
Aye.
Arisman, I, Golding,
Aye.
Borelli,
Aye.
Landowski,
Aye.
Williams.
Aye.
That carries unanimously. And that moves us to enforcement actions, potential enforcement actions.
I don't have anything specifically new this week. I wasn't sure if we want to talk about a potential enforcement meeting. Jeff and I still have to get together and comb through what I'll call our historic enforcements to me. And we're going to generate, a list of kind of what's open, what's still out there, et cetera. And I'm not sure if we want to have a special meeting about enforcements in general. That's it.
So just for some perspective, I was in the office last week and I've been trying to get at Jeff and Will about enforcements. And I think part of what we need to do as a commission is have maybe quarterly enforcement updates, just like scheduled with us throughout the year to check in on everything. But at this point, since we haven't done a check-in and there are, I think, 10 or so kind of questionable floating enforcements, to actually have Jeff and Will connect, track down what's happening with them, and then have one meeting like start off that quarterly deal, to make sure we're checking all the boxes, I thought would be maybe an efficient way to get it going, because I know, Ian, you've talked about numerous properties that should be on that list. I have a few that I've mentioned both in public and just in the office. So that was my thought to making it more efficient. And that's kind of what Will's asking. And then Ian, I know you had a comment.
Oh, then I completely agree with you, Ashley. And then I was going to ask Will if there'd been any progress with town council on Gully Road.
I believe Jeff reached out to town council. I'm not in tomorrow, but I already have a note written down to circle back on Monday with him. I think that, you know, as you've probably seen in the past, that can take a minute for them to get back. But obviously we'll see how the cookie crumbles. But Jeff and I will be talking on Monday and getting that out if he hasn't, but I'm pretty sure he's emailed them.
I think quarterly enforcement meetings would be great just to keep the commission current, and
yeah,
I just support that. Yes.
Any other questions, comments about enforcements? And I just kind of have one. Will, has Mr. McGowan replied at this point?
He did. He got back to me yesterday. He's off island. I think we're going to have a really good friendly discussion on Monday or Tuesday. Definitely seems willing to communicate and talk about what's going on over there.
Okay, good, because there was some more work that's taken place since all that. So I was like, oh, okay.
No,
what's that?
Really?
It's everywhere.
Do we have to go out and camp out there on top of the tree stumps?
I do have to let you know for everybody's information, the certified letter that I sent actually was never delivered. So the letter may not have actually ever shown up. So he may not have been aware that we're looking at the situation until literally yesterday. And that's,
How do you miss
that's
it?
coming
How
from
do you
my
miss that?
USPS tracking. It was literally not delivered by the Postal Service.
How do you miss this? It's been everywhere. How do you miss it? You living in a rock? You're living under the tree stump?
That's Nantucket's postal service that just didn't deliver
Yeah.
what they needed to. So that's good to know.
I'm just
so-
letting you know.
Yeah, no, well, that's helpful.
Yeah.
So you don't feel like there's weeks of non-compliance.
Yeah.
Sorry, I'm lost. Are we still talking about Gully Road, or are we on another site?
No,
Millbrook.
I had
Millbrook.
Millbrook Road. There's like
Yeah.
some concerning road maintenance that is destroying, quite honestly, one of the little wetlands with sedimentation.
Yeah.
So that needs to be reeled in quickly.
Thank you.
It's hard to miss it, really.
All right, so that moves us on to reports. We have crack.
Nothing to report.
Okay. CPC,
Nada.
NP and EDC.
Nothing to report.
Great. Commissioners' comments.
Great meeting, Madam Chair, again. Difficult subject for the first hour.
Thank you. I thought when I looked at this, I was like, oh, we could be out of here in an hour and a half. Well, nope.
So, Madam Chair,
yes,
I'm a bit puzzled by this discussion of Stop and Shop parking lot stormwater. I thought it was the boat basin down at the yacht club. And isn't RJ? Don't you want to address this, RJ? And did we just miss that?
So I just had my hand raised. I'm not sure if.
Oh,
Okay.
sorry. I have maybe a different copy of the agenda. Did I miss something on the
Okay.
agenda?
Yeah,
Yeah,
we
this-
skipped it.
Okay.
This got added 2 days ago, I think. If it's cool, I can just give a quick something.
Yep. I apologize about that. I got my first hard copy in a while, and
That's fine. So Ian, I think you're right. It is the boat basin.
Right.
Jeff had said something about Stop and Shop. I think I crossed a wire, but
Right.
the intention here, I think that we need, I think it's New England Development is the owner over there. But I think that we need to get them included in the discussion on what the issues are over there. And then we can also, Jeff was saying we can have a copy of their Chapter 91 license in the next packet. And then try to get them involved in a discussion about what the issues are over there, what the limitations are. I'm assuming it has something to do with the inability to dispose of the tailings from catch basin cleaning anywhere on island. I know anywhere that it's not a town-owned catch basin, there's a ton of difficulty with getting them cleaned out because there's nowhere to put the material. I think there's probably a lot of different things at play there. And I'm not sure if RJ wants to weigh in at all, or if there's any,
RJ, go ahead.
Thank you, Chair Ersman. First of all, really thankful to the commission for getting this on the agenda. I know I have been pestering you since August of 2022 about this. So it's, Will, you're correct. New England Development is the owner. It changed hands, the boat basin with those storm drains. But there have been multiple meetings, including a couple of coastal resilience advisory committee meetings for when the yacht clubs were represented. There are multiple parking areas downtown with stormwater infrastructure that is not in compliance. And it's not something where you have a bad actor. It is something where these things got installed with good intentions, and there, as Will said, there's no way to maintain them right now, and they're looking for some assistance with figuring out a way to maintain them. So this is a situation where the commission can do a significant service to harbor water quality just by getting them in here, getting the conversation going, and figuring out a solution to this, because the stormwater infrastructure here is inadequate, even if it's working. And it's not working right now. So it's really important to get them in here and to figure out some sort of solution to allow them to start to maintain that stuff properly, so we don't have runoff going into the harbor unabated, which is what's happening right now. But it starts with New England Development. So thank you very much for getting this on the agenda and getting the ball rolling. It's really important.
Thank you, RJ. Seth?
Thank you, Madam Chair, and thank you to Will and RJ for moving this forward. I'd also suggest that, although it might not help with these current situations, that the commissioners watched the select board meeting from last night, where Jeff and Roberto introduced the upcoming illicit discharge regulations that the town is trying to get enacted. Hopefully those will get towards a public hearing soon and an enactment soon, because that will greatly help all of the town government and town committees' ability to deal with stormwater. Thank you.
Thank you, Seth. Any other questions or comments on this one? And I do want to thank Ian also, because he really made sure this got on the agenda from the inside too. So thank you, Ian. All right.
A small part. I played a very small part, Ashley, but thank you.
Seth, are you raising your hand again?
Yeah, for Commissioner's comment, if I may.
Yes, go ahead.
I apologize for speaking a lot tonight. I know I drew this meeting out, but I would like us to put one additional agenda item on the 216 agenda. I know a few meetings ago, I mentioned that in the open space and recreation plan that has been presented to NPDC, it indicates that the commission owns 6 parcels of lands that are a little more than 20 acres. Will, myself, and the assessor have been able to track down 3 of these parcels. We're not sure if the other 3 parcels have maybe changed hands over time or were misclassified by the Weston and Sampson document. But we at least have 3 parcels under our ownership, or one of them is under joint ownership with the town. And we should schedule a meeting to discuss what to do with those specifically, and also to talk generally about how we want to approach open space moving forward. Thank you.
Thank you. Seth, is there any value in having the open space discussion moving forward at our regs update next week, as far as potentially addressing some of that there?
That's fine. Whatever you would prefer.
Just because I think we could maybe get something in that language, which might be helpful. And then let's look at the 216 for these open space parcels and pencil it, but I want to make sure that 216 doesn't get too big of a meeting to have a valuable discussion about those items, just because I know we do have SBPF on that one. And I want to make sure we have full focus on these properties as well, or as much focus as we can.
Thank you. In that case, we can just put it on a March meeting. That's fine.
But one of the near future. And thank you for tracking these down. Any other commissioners' comments? Looks like no administrator staff reports.
That's it. Have a nice night.
I'm still gonna get you a pool cue, so you don't have to get up for those lights, Will.
It seemed like it was happening in much shorter intervals tonight. I don't know if I'm losing it, but it happened a lot.
It did.
It's not even 8.
All right, guys, so we're at the point in the meeting where someone should make a motion to adjourn.
Yep.
All right, motion made by Ian, seconded by Joe, by roll vote. Beal,
Aye.
Engelborg,
Aye.
Harrisman, aye. Golding,
Aye.
Nizzarelli,
Aye.
Landowski,
Aye.
Williams.
Aye.
All right, this meeting is adjourned. Thank you, everybody.
Thank you.
Yeah,
Good night,
thank you.
everybody.
Good luck with the minutes, Will.
Thank you.
Have a good night.
Do it.
Stay warm. Stay warm tomorrow and Saturday, everyone.
Oh, yeah. Waiting for my pipes to freeze.
Don't go
Joy and
outside.
rapture. Joy and rapture here. And I got a post and beam. Just great.
Good luck, Linda.